Hi, y'all, and welcome to tonight's live stream. I don't know if I've ever been more surprised at the twists and turns in a case than in Brian Walshe's case, but today might be the biggest one we've had yet. We have already seen Brian Walshe plead guilty to two charges I would never have guessed he would have pled guilty to. But in opening statements, we were then promised a story that would explain everything, that would tell us how Ana Walshe died, would tell us about this sudden death that Brian Walshe claims she had. We were given big promises about what Brian Walshe's evidence would show, an explanation of the intimate details of that night, exactly what happened and when it happened. But today, we got another huge shock after an opening statement that was packed with promises. The defense rested without calling a single witness. No experts, no friends, no family, not even Brian Walshe himself. And it was pretty clear in opening that they were going to call him. Now, the judge made it clear that she was surprised. She was expecting him to testify based on what the defense had said in opening statements. But none of that happened. The entire defense case just vanished. So tonight we're going to break down exactly what the jury was promised in opening statement, what they actually got, and how this latest surprise move from Brian Walshe is going to shape what we're going to see in closing arguments tomorrow and what the jury will ultimately be deciding. So let's dive in. I want to say, if you haven't yet, would you please hit the like button? That helps YouTube know we're alive and well. If you're not subscribed, we would love to have you back for more. Please hit the subscribe button. Shout out to our first five in tonight's chat: Betsy Sue, Andrew J., American for Us, Lorna Lee, and Mickey Bassett. All right, so today, huge, stunning surprise. Let's go ahead and add it to the stage, and you can see
me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
You do not?
You do not.
All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day.
So the judge has spent last evening working on all of these specific details on the assumption that Brian Walshe was going to testify. And we're going to hear her say a little bit more about why she thought that. Everyone did, because the defense said that in opening statement. And suddenly, surprise move last minute on the morning the defense case was supposed to begin. Suddenly, Brian Walshe says, I'm not testifying, or his team says, Brian's not testifying, and we're presenting no case at all, no witnesses. We're going straight into closing arguments. The judge is trying quickly to rearrange things, figure out what exactly she needs to do, and she picks right up. Okay, then we're going to do the charge conference today, where they come up with jury instructions that she will read to the jury, and then we'll do our closings tomorrow. And she calls the jury in and tells them that. She also went through a colloquy with Brian Walshe saying, you know that you have the right to testify, but you don't have to, and you've gotten advice, but you're making your own decision, those sorts of questions. So she talked again, though, about why she was not going to allow in his statement. And again, here, go ahead and listen to it, and then we'll talk some about it.
On defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife?
So let's stop there. And that's another document you and I will take a look at in just a minute. So what was happening was the judge was trying to figure out whether or not to allow the jury to hear that Brian had pled guilty to two really important charges, one of which was lying to the police and the other of which was disposing of his wife's body. Now, a lot of people raise questions. How exactly does it work that you dispose of the body, but you didn't commit the murder? And his story, according to opening statement, you're going to hear it in just a minute. We're going to weave it in and talk about what they were telling us, was going to be that she died suddenly and he panicked. But nothing from that is in evidence, nothing at all. So what the judge is saying at this point is, I was going to revisit the question of whether or not these pleas came in if he testified, but he's not testifying. And up until now, I haven't let it in, and there is no more testimony. So the guilty pleas are not in evidence. The jury doesn't know anything about the fact that he pled guilty to those. They do know that in opening statements, his attorney acknowledged them, but what they don't know is anything related to whether or not he actually pled guilty to it. So this raises a ton of interesting questions because opening statement by the defense included a lot of references to facts that are not in evidence because Brian didn't testify. The defense rested without putting anything into evidence. And that is, of course, Brian Walshe's constitutional right. But there were promises that were made in opening that then were not fulfilled. So I want to take a look at what you can see here. This is a Massachusetts rule of professionalism that applies to attorneys. I don't practice in Massachusetts. This is not legal advice. This is similar to pretty much the professionalism rules just about everywhere, including the American Bar Association rules that pretty much all the states have patterned their rules after. And here's what an attorney must abide by. In appearing before a tribunal on behalf of a client, in other words, if you're representing a client in a courtroom or to a judge, then what the lawyer cannot do is state or allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. So in order to have made the statements in opening statement that the defense actually made, the attorney, Mr. Tipton, had to have actually believed that it would be supported by admissible evidence. And so I believe that at the time he made his opening, he must have believed Brian Walshe was going to testify, and they have changed their minds at some point during the course of this case. So we'll listen to a little bit more of the evidence, but I wanted you to see why I think that and what the rule is, because what can't happen is a lawyer just come in and say, oh, the evidence is going to show and list a bunch of stuff that absolutely no one believes the evidence will show. An attorney's not allowed to do that. And so that can't be the way it happened, at least not professionally. And I don't think there's any suggestion that the attorney did something unprofessional. But how do you handle this now, right? Because the defense, clearly from what they said immediately, was worried that the Commonwealth was going to make a comment to the jury, something along the lines of, you heard an opening statement that Brian Walshe would come testify. Where was he? You heard and even if they didn't say that specifically, you heard in opening statements that Brian Walshe went downstairs, that he stood at the sink, that he cleaned up the kitchen, and that he went back up and discovered his wife dead in the bed. So, and to his surprise, he nudged her, we were told, over and over. She rolled out of the bed. None of that, ladies and gentlemen of the jury, came into evidence. And, where is that evidence that they told you you would get? That was something that the defense lawyer was worried about. Here is what he said at the charge conference today about it.
It's a motion to prevent the Commonwealth from basically, I believe, an attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible.
So let's talk about why the Commonwealth would agree to that, because honestly, I was surprised that they apparently agreed pretty readily. Yeah, we're not going to do that in opening. It's very common on the civil side to say, remember, you heard an opening statement that defendant was going to tell you X, Y, and Z. And well, did you ever hear X, Y, and Z? You didn't. And that's because they're false. None of that happened. It's really common to do that on the civil side. But this is a criminal case. And so there's a complication here, which is the Commonwealth is not allowed to comment on the fact that Brian Walshe didn't testify because he has the right, the constitutional right, not to testify against himself. And that's what the problem is. The jury was told what he was going to come and say, and then he didn't say it. It's a really strange situation.
While the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Ana died of any natural cause.
So the Commonwealth ultimately solved this issue by saying, okay, we're not going to comment on the fact that the jury was promised things in opening statement that ultimately never came into evidence.
There was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
But remember this, the jury is not going to forget. They are going to remember the sudden death promises that were made to them in opening statement. They are going to be shocked that there was no case at all presented by Brian Walshe. I think in almost any situation, the jury is surprised when the defendant doesn't do anything. But in this case, it's going to be even more of a shock to the system because of the fact that they were promised something in opening statement. So I want to go back and look at exactly what it is that the defense said in opening statement so that we can see what it is the jury was told they would get and what they didn't get.
Brian Walshe lied to the police. Lied to him on January 4th, lied to him on January 5th, lied to him on January 7th. Brian Walshe went to Lowe's and bought tools. Brian Walshe went to Home Depot and bought tools. Brian Walshe, beginning about 4:54 a.m., began a frantic and tragic search that you'll hear about. You'll hear the evidence of that. You will hear evidence that those searches evolved from how best to dispose a body to even darker subject matter, as he wrestled with the fact that Ana Walshe was dead. That evidence that you will hear will be hard to understand, but it is true.
So the jury was told about what he had acknowledged. What he had acknowledged was he lied to the police, he disposed of her body, and they were told, you're going to hear this dark subject matter. And that much they definitely heard. They heard that from all of the state's witnesses. They heard about his Google searches. They heard about the travel he did to all the different dumpsters. This is, though, the origin of the sudden death defense that we heard for the first time in opening statement from the defense. That was uncorked then. It had never been heard before. And without Brian's testimony, can they still realistically mount that defense? They can still make it, but does it make sense anymore? So what I want to do is take a look at what the jury was told about that sudden death in opening statement, because they were told you're going to hear these things. So we're asking the question, did the jury hear this evidence? So in defense opening statement, and this is Attorney Tipton speaking, what he was doing was acknowledging all of the bad things that were basically indisputable. There was no real way to argue that Brian Walshe had not lied to the police. There was no realistic way that they could argue he hadn't disposed of the body. I mean, where else was the body? And those Google searches were so dark and so damning. And so they acknowledged what they had to acknowledge. Those videos of him buying cleaning supplies and other things, it just really difficult evidence. And I think the defense was trying to get ahead of that, to say, okay, we acknowledge that. Let's just go ahead and admit that up front. But all of that was going to be proven at trial. But now the jury also heard, in opening statements, I should say, the jury heard a very detailed explanation of what actually had happened, as if it came straight from Brian Walshe himself, except that they never actually heard anything from Brian Walshe.
January 1st of 2023, Jim Mutlow left the family home of Brian and Ana Walshe sometime between 1 and 1:30 in the morning. Ana and Brian Walshe continued to celebrate the New Year's. They went upstairs to the bedroom. About an hour later, you'll hear evidence that Mr. Walshe got up, went back downstairs to clean the kitchen. You'll see evidence that he looked at his email. You'll hear evidence that he then returned to the bedroom, intending nothing more than to crawl into bed with Ana Walshe, the woman he loved. When he entered the bedroom and began to get into the bed, he sensed something was wrong. You will hear evidence that it made no sense to him. But he nudged Ana, his wife. She didn't respond. He nudged her again, a little harder. She didn't respond. He nudged her now in a frantic and panicked reaction to where she actually rolled off the bed. You'll hear evidence that now he is panicking and he doesn't understand what has happened and what is happening. It didn't make any sense to him. It didn't make sense that somebody that he had just been with and enjoyed New Year's Eve into New Year's Day would suddenly be dead.
Really specific, right? He's nudging her. She's rolling off the bed. He goes downstairs. Really specific. And none of that came into evidence. That whole story you just heard, that's not in evidence. It was in a story which may stick in the jury's minds, but it was not actually anything that anybody testified to at trial. Only Brian Walshe could have said those things. No one else is alive to say that. Ana's not. And the story was about her body being found dead. No one else was involved. So it was Brian or nobody. And the problem is, if the Commonwealth draws attention to it, they're obviously concerned that they may be commenting on the fact that Brian Walshe didn't testify. These statements were made about what he personally would say, would testify to, because no one else could. But if they say anything about that, it creates a problem where they're saying Brian Walshe didn't testify. So defense attorney Tipton keeps going to explain that there is going to be evidence for the jury of unexplained death.
You will hear evidence in this case of sudden, unexplained death. You will hear evidence that it happens in young people and old. You will hear evidence it happens in male and female. You will hear evidence it happens during the day and during the night, that it happens. You will hear evidence that it can be the result of both mechanical and or electrical problems within the body. You will hear evidence that it might be cardiovascular, pulmonary, neurological, or other reasons. You will hear evidence that it occurs in people who have never manifested a symptom that something might be wrong. And in fact, you will hear evidence that sometimes the first manifestation that something is or was wrong with someone is the sudden, unexplained. That's the evidence you will hear in this case. Sudden, unexplained death is known within the medical community and the forensic community. But it is to this day not well understood, and that is the evidence you will hear. And it is not well known to non-medical professionals.
That's broader than what we got it sounded to me then and still does like they had experts in the hopper. They were planning to bring in some experts to talk about this sudden death and how it might happen and what the causes might be. But that was not the case. They brought no one, including experts. There was, though, some information about this. There was some testimony about this from the medical examiner put up by the state. And he did say there is such a thing as sudden death. It's rare, but it can happen. And he did acknowledge many of the things that were just said by the defense. So I think that they were going to present a broader case, but it didn't happen. And I don't think they're totally out on this one. That evidence at least is in front of the jury.
And you will hear evidence. Brian Walshe never imagined somebody suddenly died. 1 hour he's with her, he cleans the kitchen, he comes back up, and she is dead.
There is no one who could testify to that but Brian. Listen to the wording. You'll hear evidence Brian Walshe never imagined. Well, who can talk about what Brian Walshe is imagining except Brian Walshe? I mean, this is so specific. And so all of these statements are leading the jury to the inescapable conclusion that that the judge reached. Brian Walshe is going to testify. They were expecting Brian Walshe to come and talk to them. They were expecting the defense case. That didn't happen. Let's keep going.
You will hear evidence in this case that Brian Walshe and Ana Walshe loved each other. Yes, there was stress in the marriage. Stress born out of a simple problem that took its toll. And that's the pending federal case that had begun in 2018 and was still going forward. And what happened was, over time, Ana Walshe got a job in D.C. with the support of Brian Walshe. It was a huge stepping stone in her career. It paid twice the salary. And they talked about it. You will hear evidence that they had to make a decision. Brian could not leave Cohasset because of the pending federal case. So who would take care of the children? Well, Ana worked in D.C. Brian did. And he did. There was stress in commuting back and forth between D.C. and Cohasset. Brian Walshe experienced that stress too. And Ana Walshe and him they talked about it on Christmas Day of 2022. And that's what the evidence will be.
But it wasn't. It is true that there was plenty of evidence about stress within the marriage, about the problem that was being created by the pending art fraud case that Brian was dealing with, that he still had not been sentenced on. There were problems with the fact he had to keep the kids in Massachusetts while she went down to DC for this dream job and made all the money for the family. So there was testimony from her friends about the difficulties that was creating within the marriage. But the parts about Brian Walshe experiencing the stress too, we don't really have evidence about that. And the part about them talking about it on Christmas Day, we don't really have evidence of that either, because it was a phone call and Ana's not here and Brian did not testify. And so what about Ana's affair with William Fastow? We learned about that during the course of the case. The Commonwealth believes that could have been the motive that for Brian to kill Ana, that maybe he learned about it and he was jealous. He was angry that she was moving on or having this affair. Now, the defense has a very different view. They say Brian had no clue that Ana was having an affair with William Fastow.
Brian Walshe didn't know about the affair. He did know. Ana Walshe had a crush on William Fastow because she told him. And he did not react in a jealous way. And you will hear evidence that over the close to decade that these two people were in love. And all you have to do is look at the evidence and the photograph you'll see of Ana Walshe. And the evidence will establish she is a beautiful woman. And it was not unusual for her to comment to Brian, I had some man look at me today. I think he liked me. That didn't upset Brian, not over a period of 10 years. And when she told him that she had a crush on William Fastow, the man who had sold them the $1.3 million townhouse in D.C. Didn't upset Brian. He trusted her. In fact, you will hear evidence from Melissa Kirby that Ana Walshe told her, I wish you would be jealous. The evidence is
So without Brian to testify, there is no evidence that Brian did not know about the affair Ana was having. There is good evidence that Ana was trying to hide that affair, that she was going to some lengths. We heard it from William Fastow himself, that she wanted to keep Brian from knowing about it. She kept saying, I want to tell him about it. She wasn't posting about it. They were doing things to keep their relationship out of the public eye and just private. So it is possible that Brian didn't know, but there was no testimony from Brian, who would be the only one who could say, I didn't know. So the evidence about her trying to keep it secret came in through both William Fastow and the two friends who testified, Jim Mutlu and Alyssa Kirby, Ana's friend. And so we have heard, the jury has heard, that Ana didn't want Brian to know about the affair that was going on. But that's obviously not the same thing as Brian actually not knowing. The defense said that in opening, but they never brought Brian to actually say that to the jury. The family friend, Jim Mutlu, testified that that night, New Year's Eve, while they were all sitting there in the kitchen, Ana said out loud, oh, let's take a picture and send it to William Fastow. She was texting with him right there in front of her husband that night on New Year's Eve. So did Brian learn about the affair? That's clearly what the Commonwealth thinks happened, either because he was looking at her messages or maybe because he had looked at the credit card that showed that unexplained trip to Dublin, Ireland for Thanksgiving when she went with William Fastow. Maybe just because he confronted her that night after their friend left. But the defense insisted during opening that Brian and Ana still had a loving relationship. Here's what they said.
in this case is that Brian Walshe loved Ana Walshe. You will hear that she spoke of him in glowing terms to William Fastow. That she said, I want people to see the Brian that I know. You will hear how she talked about her relationship with Brian with Alyssa Kirby. And notwithstanding the fact that Ana Walshe was having an affair, there was...
And actually, even though Brian was, or I should say, was not there to testify about it, did not show up to testify about it, nobody would have believed it if he had said that anyway, because he had such incentive to lie about that. And so the evidence that did come in wasn't quite as strong as what the defense suggested in an opening statement. Fastow did say that Ana spoke well of Brian, but the friends, Alyssa Kirby and Jim Mutlu, both said Ana was breaking down over all the problems with Brian, with the art fraud case, that it was really damaging their relationship and that she was considering various actions. It wasn't totally clear what. So she even suggested to Alyssa Kirby that she wanted Brian to think about taking that sentence in the federal case, just get on with it, because they were in suspended animation. The boys and Brian waiting in Massachusetts. She was separated from her children. So, but the defense was very clear that Ana and Brian still loved each other. Here's what the defense said.
The importance about those text messages that you'll see is simply that they're dated. The ones you'll see are dated beginning December 25th of 2022, 7 days before New Year's Day. 12:25, Ana Walshe and Brian Walshe are texting each other, and she is sending him 7 properties, listings, primarily out of Zillow, 7 listings of properties in the greater DC area. Bethesda, Annapolis. They're searching for future investment.
So the point the defense was trying to make was that they were, first of all, that they loved each other, that they were texting each other, and they were looking forward together. They were going to buy more properties together, not alone. It's not as strong, I think, just because of the fact that there were deadlines for them to reinvest this. We heard from some of the witnesses she had 45 days in which to declare what the next property would be. So it may just be that they had to go ahead and do it. But the defense is trying to say they had a lot of reason to move forward together, and there was nothing suggesting that they were about to end their relationship. And there was testimony also about how they were looking to reinvest that money in the Zillow properties, also about how Brian was looking for a Porsche because Ana wanted one, about how he bought her a diamond ring for Christmas. So according to the defense, they had a very good relationship. And the one time that Brian searched for divorce was for only 21 minutes on December 27th, 4 days before Ana died. And so let's go ahead and listen to what he said about that.
The evidence will show that the only time Ana Walshe talked about divorce with William Fastow, she talked about it in terms of Brian and I attempting to preserve the family assets. Why is that important? Because yes, there was $400,000 of restitution that was going to come due. And yes, Brian may have had to go to prison for some time. And what did that mean? It meant that there was going to have to be arrangements, not just to pay the money, which wasn't going to be a problem, but the boys had to move up to D.C. because Brian could no longer take care of them. And there would be all that added expense. And they went so far as to talk to Robin Howe, their nanny, their babysitter, and asked her if she would consider moving up.
So we never heard from the nanny, right? We heard we were going to hear that they had asked the nanny maybe to move down to DC when the whole family moved down there, but we didn't hear about that. We heard nothing about the arrangements to pay the money. We did hear that there were witnesses who were talking about the fact that Ana Walshe made great money, and the family was making as much as $360,000 a year between Ana and Brian, mostly Ana's. But while that sounds like a lot, remember, they were facing having to pay more than $400,000 in restitution, which was more than a year of all their income, and all related to Brian's art fraud. So I think even people making $360,000 a year who were suddenly faced with more or less a fine of $400,000 would be worried about that. I think that would create financial stress. So Brian's lawyer said what Brian was doing with these searches was not looking for a way to divorce Ana, but considering the idea of whether he could protect her and could protect the boys and could protect the assets without having to turn them over to the government. Could everything be separated off and given to Ana through the divorce, and then he wouldn't have to pay that amount, or he would owe it himself after he got out? So, and here there was a specific promise to the jury that Brian Walshe was going to testify. Listen to this.
So there were expenses. So when you talk about preserving the family assets, you have to decide, how is it that I make sure, how is it, as Brian Walshe will tell you, how is it that I make sure that my wife and my 3 sons are financially secure if I have to go to prison for a day, for a week, for a month, or for years? That's what they were talking about.
Now, the defense told the jury, Brian will tell you, but he didn't. And since Brian didn't testify, nobody testified to that. The defense created this entire mental explanation for why Brian Walshe lied to the police, for why he disposed of Ana's body, but Brian never came to explain it to the jury. This is not in evidence. Listen to what they were told, but what isn't in evidence.
And Jim Mutlow left around 1:30. Brian Walshe and Ana Walshe went upstairs. He went back down to the kitchen about an hour later to clean it up. And then the impossible, the unimaginable. It didn't make sense to Brian Walshe. It was confusing. He never thought anybody would believe that Ana Walshe was alive 1 minute and dead the next. All he could think about were those 3 boys. What would happen to their 3 boys now that Ana is no longer here? What will happen if they think he did something bad to Ana? Where will those 3 boys go? And so, he told the story. He tried to hide. so he could hang on to his bull. Brian Walshe never killed him. Brian Walshe never thought about killing him. Never.
Take a look at the
Okay, let's go ahead and pull that out. And I'll make this a little bigger so we can talk. So the jury never got that. The jury was told that in opening statement about Brian's panic. And it makes sense in the sense that he was facing prosecution in federal court. He was facing, he'd already pled guilty to it, but he was facing sentencing for that. And he very possibly was going to go to prison. He very possibly was going to owe this huge amount of restitution. So would he have panicked when his wife died suddenly? Maybe, yes. Would that panic lead to dismembering? Would that panic lead to using, for who knows what reason, all of those tools he bought? Would he have needed all those cleaning supplies? He would have had to explain that on the stand if he had taken the stand. So this worked out really well for the defense because these ideas were planted in the jury's minds, but Brian never testified. He never had to go through cross-examination. And I honestly cannot blame him for not testifying. It would have been epically disastrous, just absolutely one of the most incredible cross-examinations of all time, or at least it could have been. The Commonwealth would have asked him about some of these things, about whether it was true that their children played upstairs while he cut his wife into pieces in the basement and threw those into random apartment complex dumpsters. I mean, how do you get past that? And I think all of those questions could have been on the table. The jury, I believe, even though Brian Walshe did not testify, I think they will remember these promises. And if the Commonwealth, even if the Commonwealth does not mention it because they don't want to run the risk of suggesting that Brian Walshe said he was going to testify and to calling any attention to the fact that he is not, even so, I think the jury will hold it against the defense. In mediations, I tell attorneys the worst thing you can do is violate the other side's expectations. And that is exactly what happened here. The defense told the jury, you're going to hear these intimate details. You are going to hear from Brian Walshe. You're going to hear what he found that night. And you're going to hear why he did what he did, that he panicked. You're going to hear about that. But it didn't happen. And the jury, I think, won't forget about it. And they will be disappointed not to get that evidence. So we'll move into some Q&A. I've got some folks to thank over here. First of all, I want to say thank you to Jenda Baum, saying all those cleaning supplies scrubbed the defense. That maybe they gave up after. It was amazing evidence, the way they were able to find such specific evidence of Brian Walshe purchasing the various cleaning supplies at numerous stores. And then they had the receipt there to show exactly what got purchased. It was remarkable. It really was. Miss Spunky, thank you so much. Not just once, but twice. A super generous gift. I'm really appreciative. Thank you. And Mrs. Cincy John gifted 5 lawyerly memberships. Thank you so much. We're going to be doing a members only next week. So perfect timing. Thank you, Mrs. Cincy John. And also from Miss Spunky, who gifted 10 lawyerly memberships. Thank you, both of you. Very appreciative. So Pascaline opens us up with our first question. And she wants to know how the jury got aware that the defense had rested his case and Brian was not going to testify. So what happened was, after the Brian Walshe team gobsmacked the judge, and she was stunned to learn that he was not going to testify and they were presenting no case, she brought the jury in. She said, does the defense have any evidence to present? Or does the defense wish to present evidence? I think is how she phrased it. And he stood up and said, the defense rests. And then she said, okay, well, this is the end of the next chapter in the case, and you can leave for the day and come back tomorrow for closing arguments. You'll hear those tomorrow, but we're going to be working on the jury instructions today, the attorneys and I. And that's the way it happened. That's how the jury learned. There was never a statement, we're not going to bring Brian, or we're not going to bring experts. It's just we rest and nothing happened. Now you go into closing. So I think the jury would have been very surprised by what happened. Lisa is concerned about the question of whether Brian Walshe will get off. I think one important thing to remember here, Lisa, is that he is going to go to prison. He has already pled guilty to 2 charges that together would add up to 23 years in prison at the maximum. As far as whether he'll get that full amount, he hasn't been sentenced yet. We don't know for sure. I wouldn't be surprised to hear it. And particularly wouldn't be surprised if he got the maximum if there were no other sentence. So I don't believe there's going to be a situation where he gets no prison time. I think that is happening. Johnny NY, Johnny New York, I guess, is asking if lawyer's statements are not evidence, how can the jury consider sudden unexplained death? Only Tipton said those words. Seems a foul to let his questions to the medical examiner inform the jury. How can this be? And what a great question, too. As far as he was allowed to ask the medical examiner about his theories, and the medical examiner agreed in this particular case that sudden death is a thing, that it's a possibility. It can happen. It does happen. It's rare. It's rare in a healthy woman like Ana, but it happens. It's not out of the question. It's not something that the defense lawyer made up entirely. So I think there is enough evidence from the medical examiner to at least make that argument to the jury. So I think we will hear from the defense tomorrow that it was a sudden death because he got enough of that to be able to make that statement to the jury. He even said specifically he wanted to make that argument to the jury tomorrow. So I think that's where it will come in. Now, and to some extent, you're asking, how can he ask the medical examiner about that? And I think he got the actual answer from the medical examiner that it did exist. And I think that's why he's going to be allowed to make it. If there had never been any evidence from anyone about it, that might have been I don't think he would be allowed to make that in closing. And Kimberly, thank you so much. You know what I forgot to do? I forgot to say, please put question marks at the beginning of your question so I have a better shot of seeing them. So now, having waited to do that, hopefully you can put them back in again if I miss it. But thank you, Kimberly. Much appreciated. Okay, let's head over and see what the questions are over here. I saw somebody, I zipped past it, but somebody said, I was disappointed. Right? I was too. I was really looking forward to that cross-examination because it should have been just absolutely fascinating. AG asked me, do you think the kids saw anything happen? I don't think they did. There's no suggestion that they did. And the police did talk to the children. So I don't think they saw anything. And thank goodness. You know what? I want to continue believing that. So I'm just going to stick with that. But I do think, honestly, that they did not see anything. I think that that's the case. And I hope that that's the case as well. Okay, so I'm looking for those question marks at the beginning of it. And if I missed yours, then I'm sorry. So Mama Don asked, do you think that Tipton knew all along that Brian was not going to testify and he just said all of that stuff and opening statements to get it into the jury's minds? Oh, Mama Don. So is it possible? Yes, but it would have been a violation of his professional duty as an attorney. So I don't think so. I don't think he thought that from the beginning. And they let the court and the judge think that all the way through yesterday so that the judge showed up surprised. For that reason, I don't think it was. But I understand that a lot of people will be suspicious about that whole story was told so that the jury might think that. And so that the entire time that they were hearing the evidence from the state, they might be thinking, but isn't it possible that all of this is true and yet he found her suddenly dead in the bed? Isn't that possible? So my guess is no, but I understand that there will be people who will be skeptical, but my personal opinion is no. Tammy, I remember the second trial of Karen Reed. We were told Proctor was going to testify in the second trial and he never did. So isn't it the same? Well, it's certainly true that we never heard from Michael Proctor. So yes, it's definitely true, Tammy, that we did not hear about it. And it does happen sometimes that the either side can change the way they want to present the case, or maybe testimony comes in through one witness and you don't need this other witness. Typically, though, lawyers are very, very careful about what they say in opening statement because they know it's like a promise to the jury. It's like a contract. Here's what you will see. Here's what you will be looking for. Here's your roadmap to what we're going to show you. And if you then don't show the jury that, there's obviously going to be a problem in the jury's mind. So lawyers work very hard usually to keep those opening statements clean and only filled with evidence they know for a fact they can present. The judges approved it or it easily would be approved, and they are going to present that. People aim really hard for that because lawyers are looking to establish credibility with the jury so that what they say, what they argue, the jury will believe. If for any reason you say things in opening statement, that's why in a civil case, it's very common. So you said you heard you were going to hear blah, 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 but did you? You did not. And the reason is because that undermines the credibility of that side and of that attorney. And so people don't want that. They don't want to present something in opening and then end up having to walk it back. Jury never hears about it. Okay, looking for those question marks. Thank you, Mama Pink's one of our mods, reminding people to put the question mark at the beginning. So hopefully people did. Are Brian's guilty pleas coming in? Asked Freddie's cat. No, the judge ruled it's not coming in. I am not sure I completely agree with her decision, but she said she was not going to let those come in. Her biggest concern seemed to be that she was afraid that the jury would be tempted to think, well, he's already getting punished for these other things, so I don't have to convict him of the murder. And I understand her point. She said, the jury's not supposed to think about penalty. The jury's just supposed to think about whether or not there's guilt in this particular case for this particular claim of murder one. That's all the jury is supposed to be doing. But the problem with that is the opposite is true also, because they've heard all this terrible evidence. And if the only place they have to shove it is murder one, and otherwise, as far as they know, he's going to walk free, having acknowledged that he lied to the police, having acknowledged that he was disposing of her body in this gruesome and horrendous way, or at least a fair amount of it. We got enough between his admission and opening and the evidence that we got from the Commonwealth. I think it's pretty clear. So if the jury has all of this terrible stuff that they believe he did, and they believe he's going to walk off scot-free if they declare him not guilty, there will be no punishment at all. I think the jury will say, murder one. Close enough. The guy's terrible. Murder one. That's what I think might happen. So I understand the judge's concern that she doesn't want to give the jury a reason to sentence him or to let him off because of the fact that he might get time for the other crimes. But honestly, I think it's going to have the other effect. I think it's backwards the way that it's being considered. So my personal opinion, I would have let that in. And she seemed to say from the judge, there's no clear law on it. I don't have a case I can refer to. I'm just having to figure this out as I go. So Loretta Powell asked, what evidence supports premeditation? Well, they went through a list of those things. We'll probably hear them tomorrow when we hear the closing arguments, but let me see if I can recall what some of the ones that they argued were. The evidence of his search for divorce, the evidence of her, some of them were kind of like her not being there for Christmas and looking for him. They also have argued that all of the stuff that happened afterwards is evidence of his consciousness of guilt, that doing things like buying cleaning supplies, hiding the body, just dismembering the body, doing whatever he did to her body, that was done to protect him because he knew he was guilty. That was the only reason for that. They also believed that his lost phone was part of a plot designed in advance to make sure that he would not have any evidence against him when he went to all these dumpsters. So it's things like that, Loretta, but we'll hear far more about it tomorrow. They went through a whole catalog of them with the judge. Okay, do you think Walsh's mother had a part to play in this? Asked definitely David. I don't, David. I don't see any evidence. And certainly I know that the Commonwealth hasn't charged her with anything or suggested she did. There was no evidence presented. It wasn't like they had her phone going to his house or, her phone going to dumpsters, none of that. So it didn't appear that she had anything to do with this. Pippa Scott Music. Do you think the defense resting is because they feel they have proved their case or because they're giving up? I am just stunned. Pippa Scott, I really don't understand. I really thought we were going to have Brian come and give this explanation. I believe from the beginning that the defense has really pushed hard on this very technical point. It is a legal point that in order to be convicted of murder one, Brian Walshe has to have actually had malice aforethought. He has to have premeditated the murder of his wife. And there is not a lot of evidence from the Commonwealth about that. It's very little. Most of their evidence comes after the fact. So why would they be resting like this? I think they know they have a very technical argument, an argument most likely to be important on appeal, less likely to be effective with the jury. And maybe so it's not quite giving up. I'm going to say that it's not giving up exactly, but it's recognizing where this would best be made. Genda Bomb, thank you so much for gifting a Lawyerly membership. Much appreciated. If you are not a member, first of all, you can always join by hitting the join button at the bottom right below the channel, right next to the channel name. But also, if you want to receive a free gifted membership, our mods will put in the chat how exactly you can turn on your ability to receive a gifted membership from YouTube. So Pray Then Hustle suggests that the lawyer can say anything during opening statements. I think it's asking me, can the lawyer say anything during opening statements? The lawyer can say anything that is reasonably believed to be evidence that will come in at trial. So the lawyer has free rein to talk. No one's looking over the shoulder saying you can say this, you can't say that. But it has to be things that the lawyer thinks the jury is actually going to hear, that will be presented in evidence. That's a rule of professionalism that governs lawyers, and they're supposed to, whenever they're in front of a tribunal, a court, they're supposed to make sure that they're presenting things that have a reasonable basis. So thank you very much for the question. So Gringa wants to know, Gringa L, scale of 1 to 10, how well did the jury prove first degree, or how well did we prove first degree to the jury? And I'm going to hold off on that since the jury hasn't made a decision yet. I'm not going to respond to that, but I would be very interested in your opinions. If you would stick those in the chats or in the comment, I would appreciate it. Please do that. And let's see. Gringa changed the question to Gringa L to how well did the state prove first degree? I figured that's what you meant, Gringa. So, and I think that the state has a bit of a tough time with the premeditation, with the malice aforethought. Their evidence for every moment following the crime is outstanding. It is stellar. Law enforcement was phenomenal, but there isn't a lot on the time beforehand. But I think they did a good job getting in some things like the friends who talked about just 2 days before New Year's Eve, Ana Walshe was breaking down. Ana Walshe was talking about how she was falling out of love with Brian. Ana Walshe was talking about how she might need to make changes. She wanted the boys in DC and she was ready to have that happen. So those sorts of things, I think the Commonwealth will use effectively in closing argument tomorrow to argue to the jury, this is your evidence. We don't have direct evidence. Brian never typed out in a text, I'm about to kill her, but he did do enough that you can figure out, you can use this circumstantial evidence to show you it was malice aforethought. So I think that's, so I won't give my personal opinion, but I would be interested in people. So that's a good way to do it, Gringa L. Why don't we do scale of 1 to 10? If you think the state proved first degree murder all the way, give it a 10. If you think not at all, there's just no malice aforethought, put it down at 1. And I will be very curious where everybody ends up in the chat. Okay, we'll do a couple more. All right, I think I already answered Tammy's question. Montana is asking about Brian's behavior about using his son's iPad. And does that speak volumes to the jury? If you've been watching the channel, you know that even more than the iPad, what just sent me over the edge was when we saw Brian shopping in Home Depot with his son and his son carrying bags. That was on the 4th. So probably just cleaning supplies, but I don't even care. I don't even care. The fact that the kid was taken to Home Depot and it had anything whatsoever to do with this case, I don't even know what to say. It's appalling. And that really bothered me a great deal. Will it bother the jury? I don't know. I don't know for sure that they noticed that. He did use his son's iPad, although actually, now that you mention it, Montana, there was testimony that the actual searches themselves were not done on the iPad, that they were all sharing some kind of, I don't even know what, I don't know the terms on this, but they were sharing their searches and their data and information. And so actually the searches were done on the main computer and then they were just picked up or came out on the iPad. So I've forgotten about that. There was some testimony about that. Buttercup, why didn't his mommy testify? And I assumed that she just didn't have anything specific that would be helpful to him. And even if she did, maybe they would have put her on if they'd had other witnesses, but for her to testify alone, that wasn't going to be sufficient. They figured it'd be better to just go straight to the jury and forget the whole defense case. All right, Libby Christie, thank you so much. Much, much appreciated. And Johnny thinks the Commonwealth is being outclassed by Tipton's skills. So Tipton is an excellent lawyer. He really is. I continue to think I just am going with this wasn't a strategy. That's what I'm going with. But I understand fully that people will believe it was a strategy from the beginning. It certainly has been a very unusual case, starting with the guilty pleas. Really, really unusual. He told his parole officer he needed, says Shelley Anderson, that he needed 6 hours to return his mom on the 1st, but she wasn't there. That is true. He did tell her that, but she wasn't there, which I believe to be the case, and which she would suggest she wasn't involved to answer some of the other questions. But he did say something about needing this time to return his mother, even though she wasn't there, and why was he asking for that? He used the time to do all this shopping. But as far as his reason for it, that had to be stated in advance. So that's a really good point, Shelley Anderson. All right. So I said we were going to take a couple more. Oh, wait, there's one. Barry Adams asking me, if there's a conviction and it goes up on appeal because of the searches and the warrants and comes back for trial, could Brian Walshe rescind his pleas on 2 and 3 because they seem predicated on the ruling about the search? No. If he's pled guilty, I don't think he'll be allowed to retract that. I mean, he pled guilty and said, I did it. He made statements and I did it. He said, I'm doing this knowingly. I've gotten advice from my attorney. I understand what this means and I did it. I'm going to plead guilty. So I don't think there's any going back from that. I think his statements will bind him. All right, let's see. Last question. I'm looking for those question marks. I am not finding those question marks. Maybe we've covered everything. Oh, here we go. Mandy wants to know, why do the perps wear ankle monitors that are not GPS monitored? What is the point? And I think she's referring to the fact that Brian Walshe seemed to be able to go in and out rather freely. We heard from his parole officer, his federal parole officer, that he was supposed to stay in the home unless he got permission to go out to a specific location. And he had to do that in advance, and it was only necessary places. And obviously he went to unnecessary places, like, for example, the dumpster behind an apartment complex where he didn't live and had no business being. But those were not pre-approved, and he wasn't supposed to be doing that. We heard that from the probation officer who testified. So as far as why the ankle monitors, if he had one, I don't even know if he had one, but it did not appear to be monitored. It didn't appear that it was anything that was they used to track him or figure out where he had gone in the course of the investigation here. So I presume not. He may not have even had one, Mandy. And I'm trying to read that. Old gal Corona. Okay, I got that. Old gal Corona. How long would you say it would take the jury to get a verdict? Okay, that's going to be our next question. I want you to go ahead and put that in the chat or in the comments. Go ahead and give me your estimate. In fact, we'll do a poll. We'll do a poll on the channel, so be looking for that. There'll be a community post, and I'll do a poll. But my personal view, for those of you who are watching, I think it's going to be really fast. I don't think there's a lot for them to consider unless they really get into a specific argument over that issue around malice aforethought. If they get into that, then maybe it will take them more time. So Pascaline wants to know whether it's an ethics issue that you can't lie to the jury. Can the defense be held in contempt of court? If the defense had a reasonable belief at the beginning of the case that this was going to be presented to the jury, then no, that's all he had to do, was have a reasonable belief that it would. So if he had made a decision in advance that Brian wouldn't testify, but he told the jury all these things Brian could say, but he knew that Brian never would, that would have been a problem. But from what I gather, this is a well-respected attorney, so there's not any suggestion that he did that. Well, we will be live again tomorrow, 100% for sure, at 7 p.m. We're going to be talking about the closing arguments. Will we have a verdict to talk about? I will let you know tomorrow. So be sure, if you haven't hit the like button, please do, and subscribe with notifications on, because you are going to want to hear tomorrow night